everyone, I'm CA Sakshi Vivekjan and I'm from Agra. Welcome back to episode 2 of our newly launched series that is particularly designed for CAs and CA firms. DPDP, the failure that may collapse your CA firm. So today in this video, we'll try to understand why the engagement letters are no longer a defense after the DPDP Act. So if you still believe that your engagement letter can protect you from DPDP penalties, you are operating under a false sense of security. And let me tell you, this false security is exactly what regulators penalize. So let's be very clear. What is an engagement letter? Engagement letter is a private contract between you and your client, right? And DPDP is the central legislation. So obviously, no contract can override a statute. So no disclaimers, no clauses, no indemnity can dilute DPDP regulations. Okay, let me leave you to a real life situation. So what we as a CA firm normally practice, say for example, our firm is engaged in a GST compliance or an ITR filing. The client signs an engagement letter and shares his personal data. Now what as a CA firm we assume, we believe that we are professionals and not data company. The client has voluntarily given his personal data and the engagement letter limits our responsibilities. And let me tell you, these assumptions are the only risk. Now let's talk about what goes wrong. Let's take a scenario one where your client data is stored internally, for example, your laptop, desktop, or local server. So your multiple team members from your office access the same folder using common office login credentials. The access of client data is not restricted role-wise. The files are downloaded and reshared internally. The client data is retained even after the work is completed, unless otherwise required by law. So this is called careless handling of client data and it is treated the same as unauthorized access under DPDP Act. Please note DPDP Act works on preventive measures and not post-damages excuses. So under DPDP, you are required to prevent unauthorized access and not just wait for damage to happen. So even if there is no complaint by the client, no financial losses, no leakages reported, non-compliance is equals to violation under DPDP Act. Now let's talk about where the damage is done. For example, your system is compromised. The client is complaining about mishandling or misuse of data. The client's data is found circulating or missent, or the regulator suo motu seeks compliance explanations. Your CA firm will be asked to demonstrate safety controls, access controls, retention policies, and accountability mechanisms. And there you will stand in front of them showing them your engagement letter. And they'll open up your engagement letter and they'll ask you, is this engagement letter able to tell us why the client sensitive data was stored internally? Is this engagement letter able to answer us why the client data was not access restricted? Is this engagement letter able to tell us why didn't you secure your storage system? And that's where engagement letter fails, because it only defines the scope of work and not why the firm fails to protect clients' personal data. So using common office login credentials is a major red flag under DPDP, because when such thing happens, you will not be able to demonstrate who accessed what. You will not be able to detect the misuse or the error. You will not be able to prove the accountability. And finally, your CA firm will be responsible irrespective of the engagement letter that you relied upon. Now let's talk about scenario 2 where the client data is stored externally, I mean the cloud servers. Before that, please understand cloud providers under DPDP are only data operators. Your firm remains the data fiduciary and the ultimate responsibility lies with data fiduciary under DPDP Act. If you are not familiar with these terms, you may refer my playlist DPDP Act 2023 where I've already explained the important, basic and the most relevant definitions and sections of DPDP which will help you to understand DPDP in detail. So now let's talk about your cloud provider system gets compromised. Again, regulators will ask CA firm only because you are the data fiduciary. Why did you choose this particular cloud server? Did you assess their security standards before? Did you contractually bind them to DPDP level safeguards? Did you ensure breach notification obligations? Did you limit data uploaded to what was necessary? And the same thing will happen. You'll show them your engagement letter, and again, the engagement letter will fail to demonstrate these queries. And once you fail to demonstrate these, your firm will be liable, your firm will be accountable for any data breach, irrespective of where the data was stored. So, what I'm trying to explain is engagement letters define expectations, but only preventive measures can protect your firm. So, this is all for today, and in my next video, I'll explain what CA firms can do beyond engagement letters to stay compliant with DPDP regulations. So, if you like this video and if you feel the urgency to know DPDP in detail as a chartered accountant or a chartered accountancy firm, stay tuned and wait for episode number 3. Thank you so much.